supposed to be seated.
You're supposed to be seated today. John is seated today.
Yeah.
John is seated.
Thank you. Well, good evening, everyone. Welcome to the regular meeting of the Woodbury Zoning Commission, Tuesday, April the 10th. Seated for this evening's meeting are Commissioners Overton, Clark, Cosgriff, and Teets, and alternate Murphy. There were no public hearings on tonight's agenda, but the first item is to hear from Town Attorney Richard Roberts of Howard and Sage is here. There have been a number of issues discussed over the past several months regarding the sign regulations, the constitutionality, regarding privilege communications with attorneys, and with respect to executive sessions. So at the last meeting, the Commission agreed to submit several issues to the Town Attorney to come and talk to us about that. Members of the public are advised that anyone can speak during privilege of the floor, but unless we're in public hearing, it's not an interactive session with the public. So if you have any questions or comments, please hold it until privilege, and we'd be happy to hear from you at that point in the meeting. So essentially, can I turn it over to you and introduce Richard Roberts of Howard and Sage to our Commission and to the public. Thank you.
Thank you. As you noted, I received a list of a variety of questions. Unless the Commission feels otherwise, what I think I'll do is talk about the first two, then to the extent that you have questions or discussions, we can take it at that point, and then pick up the last two and kind of do the same thing, because it'll break up the flow, and it won't be a diatribe, but also the subject matter is pretty similar. The first two questions basically are parallel. First is, does the United States Constitution prohibit the regulation of signs which express political or related opinions? If not, are there guidelines which the local regulatory authority must follow? The second question is essentially the identical question with the Connecticut State Constitution as the document that we're talking about. I think as a starting point, there are some kind of clear answers to these questions. Once you get beyond kind of the clear answers that have been provided by the courts, you get into differences of degree, differences of interpretation, and so forth. And what I'll say is basically my best guess or my professional opinion based on cases I've looked at and so forth. It's not a guarantee of the outcome of anything. Unfortunately, for commissions like yours, as with so many things, you don't know you're right or wrong until 2.5 years later when a judge has told you whether you're right or you're wrong. But I think I can kind of give you at least a roadmap to follow in determining what direction you can go. Obviously, political speech is protected by the First Amendment, and as a constitutional matter, both at the state and federal level, the protections are quite strong. Notwithstanding that, courts have long held that states and towns can regulate signs that contain political speech. It falls under the heading of the time, place, and manner restrictions that can be permitted to be imposed on signs. Basically, content neutral, meaning whatever kind of sign it is, if you treat them all the same way in terms of how long they can be up, how big they can be, where they can be, how high they are. If you treat a sign for a laundromat, a wood chipper, a political candidate, all the same, as long as you have reasonable time, place, and manner restrictions, regulations, courts have found those to be acceptable constraints on signs in the past. In other words, as long as you regulate them regulate commercial speech in the same general way and no less you don't regulate political signs any more restrictively than you regulate commercial signs. You may be able to satisfy the time, place, and manner restrictions for having the regulations be found constitutional. There are a variety of cases, and at the request of some of the commissioners, I sent basically the ones that I had on hand that I had looked at and printed off when I wrote the opinion in November of 2010 when we were talking about this in the first place. As I said at that time, that's by no means, the universe of cases having to do with signs and political speech, but it was just the ones I had on hand, and I also included a few articles that I've been able to locate too. So generally, your regulations, to the extent that they regulate time, place, and manner of signs, including political signs, are subject to what's called strict scrutiny. And the analysis is whether the regulations are sufficiently narrowly tailored to further a substantial governmental interest. And those are a whole bunch of legal terms that have tremendous significance in constitutional law as far as what kinds of regulations are permissible infringements on what would otherwise be constitutionally protected speech. And I think the imagination can run wild in figuring out what kinds of regulations various towns and states have enacted over the years and how they're applied, how they're enforced, and so forth. But this is the framework that they're all reviewed under. Courts have found that the states and towns do have a substantial government interest in regulating signs to prevent things like blight and visual clutter and danger to drivers and so forth. The important thing with that is that we're still here talking about regulating signs generally, not necessarily singling out political signs for any other kind of treatment. So this is the test that would apply to those, to the analysis of sign regulations generally. When you go beyond the general regulations and start singling out political signs for a different treatment, you cross into a much more difficult regulatory area because you're regulating the content of the speech, which is something that courts are very reluctant to sustain. If your political signs, for example, have smaller size restrictions, smaller number restrictions, if they can be up only a shorter period of time than the St. Mary's Church Bazaar yard sale car wash signs, you would have to demonstrate that those restrictions serve what is called a compelling governmental interest. And, frankly, that test is rarely, if ever, satisfied. So, to kind of back it up a little bit, if you're going to be regulating political signs any differently than you regulate signs generally, including commercial signs, identification signs, and so forth, you have to have a damn good reason. And courts have been very reluctant to find good reasons for treating political speech any more restrictively than commercial speech. One of the ones that I sent to you, it's the Ladue West Supreme Court case. The village there initially started a regulation which said that nobody can have a sign larger than 1 square foot in their yard, and it listed 10 specific things that the signs could be about. And this woman put up a big sign saying, stop the war in the Persian Gulf. They ordered her to take it down. Then she put up a 1 square foot sign saying, stop the war in the Persian Gulf, and they ordered her to take it down. And that went all the way to the U.S. Supreme Court that basically said, no, it's not a reasonable restriction. You have no compelling government interest for, regulating political signs when you're allowing for sale signs, no solicitor signs, dog for sale, that kind of thing. And it held that there was a substantial public and constitutional interest in allowing people to have political speech at their homes as opposed to, you know, some other places. There have been a variety of other Federal Circuit and District Court cases since then. One of the interesting ones, and I won't bore you with all the details, it's the Sugarman case out of the Southern District of New York from 2002. And what's interesting about that one is that a woman was running for county district attorney, and she ran up against the kind of idiosyncratic sign regulations of 8 or 10 different small villages within the county. And every one of them treated and regulated temporary signs, political signs, signs generally differently from each other. And I'll skip the detailed discussion, but basically in that case, if you want to take a look at it, the court went through each of the different villages' regulations and said, for example, you're treating all temporary signs the same, whether they're political, car wash, dog for sale, that kind of thing. The restrictions are content neutral and they're reasonable, so you're okay. Then there was another one of the villages that had basically said that they only regulated political signs, but they didn't regulate other kinds of temporary signs. The court there said, no, you're regulating content, that won't work. Another place said you could have political signs up for 30 days, but other temporary signs for 60 days with a permission for an extension. The court there said, no, you're treating them differently, it's more restrictive, that's not going to work. And then the last one theoretically it regulated all temporary signs the same way, but at the very end of it there was an exemption for maybe half a dozen different kinds of signs for church-related activities and so forth. And again, the court there said, no, you're treating the signs differently based on what the content is. So, I guess the point of this discussion is that if you're going to be regulating political signs, it is per se a regulation based on content, and if you treat them any differently than you do other temporary signs or other permanent signs, you're skating on thin ice. I guess is not the legal term, but
it paints a very adequate
yeah. I think by now everybody in North America has seen the November 2010 letter, and at the end of that, I had kind of cut and pasted a whole bunch of different political sign regulations from towns all over the state, and as you can see in there, the regulations ranged from the sublime to the ridiculous. Some of them had no restriction whatsoever other than that they didn't block sight lines on the road and that they weren't within the right-of-way. Others limited them to 2 square feet, others required permits, that kind of thing. And I think the reason the regulations are all over the place is that most of the towns probably have the good sense not to try to enforce ones that they have been advised are unenforceable. There aren't a lot of, as I said, there aren't a lot of cases in Connecticut. The 2000 Connecticut Appellate Court is called Kroll versus Steer. It's a woman at Groton Long Point who put up a big billboard of like 20 square feet saying, who asked the deer or something like that. It was in response to the borough's decision to initiate hunting of deer on the island to reduce the overpopulation. And
I think it said, did anyone ask the deer?
yeah, it was something like that. And basically the gist of that case was that, because signs were restricted to X square feet, and this one was vastly larger, that the restriction was permissible because there was a substantial interest and there was no regulation based on the content. But that's just an appellate court case, and they didn't really give a whole lot of attention to any constitutional issues there. Turning to the Connecticut Constitution, I think what I'll leave you with on that one is that Some cases like State versus Linares and the Layden versus Greenwich, the beach access case, and I think it's Ramos versus Vernon, which is a curfew case, say that in some cases the Connecticut Constitution provides a greater degree of protection of speech than the federal Constitution does, but the areas of the law in which they have found that greater protection to exist don't necessarily pertain to what we're talking about here, which is the size and location and so forth. They pertain to primarily the forum in which political speech is taking place and provide a more flexible and liberal understanding of what kinds of forums political speech can take place in Connecticut than the federal Constitution does. So I will kind of stop at that point before everyone glazes over badly.
No, that was great. Thank you very much.
I have questions.
Sure. Why don't we throw it open to the commission and to staff, and we'll start with
Thank you.
Sean. You got a question?
Yeah, Rich. The first part, going back, should we focus on the Connecticut Constitution more than the federal, given the fact that there's stronger protections and it's more germane? Is there a focus that should be more on the federal level or the state level if we were trying to determine constitutionality?
I think fundamentally both the federal and the state constitutions say you can regulate signs. The difference is that as it stands now, there isn't a good, sufficient body of Connecticut law telling you how, if at all, your ability to regulate political signs differs from the rights that are available under the federal Constitution. You know, federal Constitution jurisprudence on these kinds of issues is really relatively well developed. I mean, it doesn't give you, it doesn't necessarily give you the silver bullet answer to every scenario that you're going to be confronting. It does give you kind of a roadmap, as far as where the respective third rail is on the side of the road. I don't think for purposes of sign regulation, I don't think there's enough case law in Connecticut to give you meaningful guidance on whether the protections are greater. If we were talking about things like when can you make a public statement about certain things and what public property you can use to make public statements, there I think the Connecticut Constitution clearly does offer greater protection. But as far as the black and white regulation of signs on private property, I don't know that you gain anything by focusing on the Connecticut Constitution.
Aren't political signs held above all other signs, other forms of speech? And aren't there can be no commercial signs larger than the political signs because they're held above.
Yeah, I think that was kind of what I started with, and I don't know whether you got here after that, but it was basically the premise is that yes, they are entitled to substantial protection, and that I think to the extent that you would allow commercial signs either larger for a longer period of time or in greater abundance than you would political signs, I think you would be significantly at risk of having it found to be unconstitutional, because that is...
So we can start with that premise.
Yeah.
To follow up on where my question was, the right to free speech is, I was able to find it on my own. I read everything in the Constitution. And then we have other stuff. But here's my question. It seems to me like this is a political issue because our founders were clear in the intent that everything was left to the people. The courts were never set up as the final arbitrator. The people always were. Are you, and I don't want to put any words into your mouth or even try to lead you, but who is ultimately responsible for dealing? I mean, is this a political issue that we as a board need to vote on and deal with? Because you're talking about potential lawsuit, which is sort of different. It's a very relevant matter, but it seems like it's a slightly different.
I guess you as the zoning commission have the jurisdiction to establish the policy of the town of Woodbury as far as what land uses are permitted and prohibited, what structures are permitted and prohibited. And if you make a policy decision that you think political signs are entitled to such a high degree of protection from regulation and interference that they should not be regulated in your zoning regulations, other than perhaps some kind of restriction saying you can't block the sight lines on a highway, they can't pose, a significant risk to health and safety, that kind of thing. That's a policy decision for you to make. I guess where I'm coming from is that if you have chosen to make the decision that you're going to regulate it, here's kind of the playing field that you're operating under. And, going back to the health and safety and so forth, I think the caveat on any kind of weaselly language like that would be that you'd want to have it sufficiently definite so that somebody looking at the regulations can figure out whether or not their sign is in compliance with the regulations. You don't necessarily want to have a tremendous amount of discretion or vagueness in there, because that's another basis on which your regulations can get overturned.
I read something in multiple cases that you sent us, and I think it's the Ward standard. The way I read it from the research was it was from a court case, Ward versus Rock Against Racism. This was what you're talking about, the content neutral. Do I have that correct? I know I'm probably going off the top of your head, but the standard I have is, and maybe I'll just run that by to make sure that I have it. The first part is, does the regulation burden any speech? And then if that's a yes, then it goes to the next question, which is the limitation content neutral, which you referred to. And if that's yes, does it serve the substantial state interest, which I know you talked about? And then if that's yes, does it leave open ample alternative means for communicating?
Right.
That was, when reading your material, I got that as a 1 to 6 order.
Yeah, I mean, that's kind of the generic review of restrictions on speech of all kinds. But
Okay.
yeah, you're right.
And I had found in the information, there were 3 cases that caught my eye. 2 were from the Connecticut Supreme Court in defining a substantial state interest, because we had gotten a report from the Council of Governments that talked about what is a substantial issue. And one was, and I probably got these names wrong, Johnson and Roberts versus Philadelphia. That was candidates who wanted to put signs and placards on public property, like trees, light posts. The Supreme Court ruled that the city has a substantial state interest in the, quote, goals of traffic safety and community aesthetics, which I get that on public property, but that's not a private property issue. I found one, Lewis, I don't know if it's Hustle et al. Versus Zuckerman. That was the case in Shelton, where they wanted to have rock concerts in a residential neighborhood at a country club.
Right.
And the substantial state interest there of limiting the concerts was the fact that it's a residential neighborhood and you're disturbing people.
Right.
So what I'm seeing is, I get the public property part, that makes sense to me. I get the private property part about, I have a right to use my property as long as I'm not burdening my next door neighbor, like having parties till 2 o'clock in the morning. So what I'm seeing is on the substantial state interest, because we are talking about a right, the right of free speech with political signs. It's a little different than putting a sign up for a local business. Are there any other standards under that substantial state interest that you would advise us in terms of looking out towards?
I think, and I remember a couple of the cases that you talked about. The courts have found that there is a substantial state interest in maintaining the view, for lack of a better word, and some ability to regulate visual clutter and blight and so forth. I mean, that's the basis they've used to allow regulation and prohibition of billboards on the sides of state highways and so forth, and that kind of thing. So.
But there's a context here that I think that needs to be on the table, and the context here is Woodbury is an historic town. We have historic districts up and down the middle of town, and And I think that we start from a position not of having no regulation and attempting to promulgate a regulation, but we start with a regulation that we as a commission have agreed amongst ourselves needs to be corrected. We know we have an inherent issue with our regs. We know that. We've acknowledged it, we've asked for legal opinions on it, we've acted on the legal opinion, we actually drafted a correction. May not have been popular everywhere, but it was a start. We drafted a correction which would have addressed those issues that we at least knew about, which were weaknesses, if you like, in our own regulations. So we got to that point. But, I believe that to move this discussion to a higher level, the reason why the state wanted and saw fit to delegate powers into local boards and commissions is that it's our town. And to some extent, if we stay within the Constitution, we decide what is clutter, what is blight, what is acceptable in a historic district, what is acceptable in a commercial district. And that's where it belongs. I mean, it literally belongs at this table.
I agree with most of that. However, we're talking about here a right guaranteed, and that was a basic foundation of our country, which is the right of free speech. And we have to balance a number of things, including some things you covered. And I'm delving into that to understand. I mean, I read through, I don't know how many pages, quite a bit.
Yeah.
And I'm just clarifying. I don't know, it was a lot. Good reading and thorough, and I thank you for it. I'm just trying to understand where we have here you have on one hand a right, and here you have another hand certain legally granted regulations from the state has given zoning commissions certain authorities. And I'm just trying to delve into that.
The comparison here, and we used it around this table, is you cannot yell fire in a crowded theater. That's not free speech. I mean,
no.
If I say to you, Sean, I disagree with you, I can do that. If I get 2 inches from your nose and I scream at you, that's not the same thing. So that there isn't, sometimes it's not what you do, the way that you do it. But the reason why I think that Attorney Roberts came down here was to guide us through this process of correcting what we acknowledge to be a weakness in our job. I don't think, and I'd like to go around the room and get some more opinions while Attorney Roberts is here, that the intent was to throw out all attempt to regulate as much as to correct what might have been potentially unconstitutional imbalance.
We're looking, Martin, and this is part of why we have these discussions. Yeah. You're looking at it from a different perspective than I am, and that's fine. That's what we talk about. The question is what are rights and what are the pecking orders here, and what are the rights of private property, what are the rights of free speech, versus what are the rights of someone looking at something and not liking it, going back to our testimony. And that's something I think we'll discuss at a later point. I just wanted to delve down and understand that, it sounds like we agree that we know we have to do something. And we have advice that there's things we're not doing that we need to do. So I'm satisfied under that in terms of just a bunch of us here, but the issues of the substantial state interest, it seems to be, is where we need to delve further, because yelling fire in a theater is a danger, threatening someone is a danger. You don't have a right to do that. But however, people have a right to private property, people have a right to express their opinions.
Sure.
And if 12 square feet is not sufficient for an individual to express their opinions, either in, as we talked about with Democrat Chairman Lisa Peters,
yeah,
that would be 4 signs on a property. Well, what happens if you have 8 candidates? So those are some of the issues that we're eventually
legitimate. I mean, I totally agree that the legitimacy of that kind of discussion. Can I just ask if there are other commissioners who have questions? Because at some point we need to move on to the other issues that
Jerry will drag me out of here.
Yeah, otherwise Jerry, I think, sitting in the back.